Okay, I have no idea what you're talking about.
Okay, when she originally filed for my response for this hearing, it's
Okay, I
supposed
don't
to,
know what response, ma'am, I'm sorry. This is a pretrial. I
okay,
don't know what you're talking about with a response. What was
no,
sent to you that was incomplete?
yeah, it was questions sent to me from the courthouse, from her that were incomplete. I didn't get all the paperwork. That's what I'm
Okay, but
asking. That's
ma'am,
what I'm saying.
that's what I'm trying to establish. What document did you get that you don't think was complete?
The original form that I had to fill out my response.
You mean an answer to the complaint?
Yes,
Okay, I don't know who
my
sent you
answer
that
to the
form.
complaint.
I don't know who sent you that form. Nobody has an obligation to provide you an answer for it.
Your Honor, today's this time and date set for a pretrial. We haven't been able to work out an agreement yet. We have confidence that, we're working towards that. I'm going to reach out to my client today. We had a good discussion and we're just moving towards a trial. I don't know if the court wants to set a trial date at this point, and in the interim, I'll try to get this settled.
How much time you want? We'll just schedule it on the docket and set out notice.
I think 60 days is good.
Okay. All right, Ms. Jones, you're muted. Any questions about the process? We're just going to send you notice. We'll schedule this for a bench trial. It'll be in the morning. That'll be live though, just so you know.
That's fine.
And if you can resolve it before then, that's wonderful. All right.
Okay. Thank you.
I don't think, do I have that on?
You might not. I think we already removed it.
Yeah, I think it's gone. Counsel, you got something ready?
Yes, I have two cases ready for you.
Which one you want to start with?
We'll do Lori Binder, LVNV funding versus Lori Binder.
All
Case
right,
number
your
ending in
appearance, please.
1306. Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Thank you. Ms. Binder, you can hear us okay?
Yes.
Thank you. Counsel, what do we have for Ms. Binder?
For this case, we request a 60-day adjournment. She apparently is working with Beyond Finance, whom we have worked with on multiple cases. And it's always a good end result for all the parties, but they have not contacted us yet. So she will be giving them our contact information. So
All
hopefully
right.
it'll be
So
settled.
we'll just schedule it. We'll just schedule another pretrial 2 months down the road.
Please.
All right, Ms. Binder, any questions?
No, not today.
All right, wish you luck.
Thank you.
Have a good day.
You too. Bye-bye.
Thank you. Counsel, you also ready on best?
Yes.
All right. Ms. Best, go ahead and unmute.
Hi, how are you?
It's Mr.
Mr. Best.
Mr. Best?
Yes.
All right. If you have a camera, go ahead and activate it. If you don't, we'll go along with audio only. Counsel, what do we have today?
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff. In this case, Your Honor, the parties have agreed to the entry of a consent judgment for plaintiff and against defendant for the full amount as paid for in plaintiff's complaint, and that the defendant shall pay the judgment in installments of $50 each month beginning August 1st, 2024. I will be emailing, or my office will be emailing to the defendant a consent judgment to sign, hopefully through DocuSign, to sign and return so that we can file that with the court as soon as possible.
Thank you. Mr. Best, are those the terms you've agreed to?
Yes.
Any questions about how that works?
No, no questions at this time.
All right. We'll sign it as soon as we get it in our electronic file.
All right.
Good luck to you.
Thank you.
You're welcome.
Your Honor.
Is that it for you, counsel?
I have two more at 9 o'clock, so I'm going to log out and I'll log back in at 9.
Thank you.
Thank you.
Then I have another one in a breakout room, Judge. It's Sharonda Jackson. The attorney is Sheila Siegel. Canton,
what case is
Canton
that?
1, the very first one on the docket, Canton 1 Limited.
Okay, and they're in a breakout?
They're in a breakout room, yep.
Ms. Siegel, your appearance, please.
Good morning, Your Honor. Sheila Siegel appearing for Canton One Limited, plaintiff on behalf of Attorney Record Kenneth Cohn.
Thank you. Ms. Jackson, if you've got a camera activated, if not, we'll do audio.
Okay, we'll just do audio because every time I get on camera, it kicks me out because I'm
we
around
don't
my
want
job
that.
at the plant.
No, that's fine. That's fine.
Okay.
Counsel, what do we got today?
Your Honor, we did have a nice conversation. We're not going to be able to settle it today. There may be some opportunity to settle it in the future, but we do need to get some dates, including for discovery or time.
All right, so you want me to just adjourn the pretrial with some discovery time, or what do you want to do?
Correct. Yes,
So how long? 60 days out for another pretrial?
that would be fine. And to,
Okay, and I'm assuming written discovery only?
yeah, that should be fine at this point.
Okay. All right, Ms. Jackson, a pretrial is an opportunity for me to get some information about the file so we can hopefully move it towards a resolution. I'm just going to adjourn the pretrial. Discovery is an exchange of information. It's supposed to be a two-way street. So counsel's probably going to send you a list of questions she wants answered. You can do the same. If there's documents that you think that Canton has in their possession that you need to prepare your defense, if there's questions you want answered, you can communicate all that with counsel. Understood?
Yes, Your Honor. I do have a quick question though. We did this the last time we were on the call and there were supposed to be some documents and things sent to me, but I didn't receive any questions the last time. We did this and posted it out for 60 days. So I'm just trying to understand, how long is it going to take to talk to the leasing office? Because even when I was living there, I had a hard time getting a hold of them. And it seems like the attorney's office is having the same issue.
Your Honor.
Okay, counsel?
Yeah, I mean, we followed the protocol and we had some informal discussions. So we tried to work with her. I don't think that's appropriate at this time, but we will follow the court's requirements and we will exchange information.
I don't have any requirements. You asked for discovery.
No, I will, the court's deadlines to do so. So that's all I'm saying.
Okay, all right. So do you want to just set it for trial or motion? I mean, I don't want to set another pretrial if you guys don't think you need it.
You could set a dispositive motion date too, but we'd like formal discovery, so.
Yeah, no, I'm giving you the discovery. So why don't you contact the civil department, you notice up your motion. Ms.
Okay.
Jackson, I'm assuming you're talking about summary disposition, counsel?
Possibly, yes.
Okay, all right. Ms. Jackson, what counsel's telling me, and I know we speak our own language, so I'm gonna try to break it down.
It's okay.
What counsel's telling me is she assumes based on the discovery she's going to do that she is going to be in a position to file a motion with the court. Motion is just the word we use in this business for request. So she's going to request that I give Canton a judgment based on the law that applies because there are no factual disputes with the law that applies. You'll get a chance to look at that written document. You'll get a chance to respond to that written document, both in writing and then orally for a hearing date. If at that hearing, I grant their argument, in other words, I buy their argument, I'm going to enter a judgment. If I don't grant their judgment, if I don't buy their argument, then we're just going to move forward to a trial date. Do you understand that?
Yes, Your Honor.
Do you have any questions?
No, sir.
All right, so I'm making a note. We're going to do written discovery for approximately 60 days out. Counsel will contact the civil department and actually schedule a motion date.
That will be the call of the attorney of record, but I can't rule that out. But yes, Your Honor, that's correct.
Okay.
All right.
All right. Have a good day, ladies.
Thank you very much. You too.
Thank you.
Judge, there's something on the docket, Hearst versus Galindez.
Yeah,
They're
it's supposed to be live.
downstairs. Oh, okay. Jamie's
live.
asking me. Okay. Do you want them
Yep,
sent up to the
yep.
courtroom?
Well, yeah, because I'm going to swear in Mr. Galindez and then I'm going to send them out to have their accredited
That's what I
exam.
figured. Okay. Okay.
Thanks. Yeah, so what she's telling me is she can't make that decision. That's for the attorney of record that's not to get motion. So I mean, probably just schedule it for a pretrial. If they contact us before then, they want to do a motion, we'll just do the motions. Okay, that makes sense. Yeah.
Okay, they just have Mr. Galindez, so they're waiting for the other party.
Oh, okay. Yeah, because he sent something in yesterday and tried to get it the date changed.
Oh, okay, okay.
Which we didn't even respond to because we got it in yesterday. I'm assuming you didn't respond to it. Jack told me this morning. Yeah. Hey, you got a Mr. Galindez down there. So he's scheduled for a creditor's exam. Was that a call or an email yesterday? You don't know that? He told me it was an email. All right. So we got an email yesterday sometime from the plaintiff asking for a new date, which we ignored because it came in so late. So if Mr. Hurst doesn't show up by 9:30, then we'll just tell Mr. Galindez he's free to leave. All right. Thanks.
And by the way, that is an incredible video that's just going down last year, 2 years ago.
Yeah.
It's July.
Mr. Harper, just stay muted. I have you checked in. We're waiting for the other parties. Miss Olivia, are you ready on Miss Perkins?
Yes, in my other case, I do not anticipate the defendant to show because we filed the signed paperwork to dispose of the matter last week.
On Poindexter?
Yes.
Okay.
Well, I need to go on the record for that one.
Say that again, counsel. What do you got?
I was asking about Jacqueline Poindexter is the defendant. I do not anticipate her appearing because the paperwork disposing of the matter was signed and filed with the court last week.
Okay, yeah, that's fine. Thank you.
Okay. Okay, and I do have another matter that is ready.
They're ready on Perkins.
Go ahead with your appearance.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
And this is on Perkins.
Yes, it's LVNV funding versus Angela Baker, who is now known as Angela Perkins.
Okay. Miss Perkins, can you hear me all right?
Yes.
Okay, counsel, what do we have?
We have resolved the matter. My office will be emailing to the defendant a stipulated order of dismissal, wherein it'll indicate that the defendant is to pay $100 a month beginning August 28th of 2024. And once the full amount is paid, we will stipulate to dismiss with prejudice. If there's a default, then plaintiff will be entitled to submit a default judgment for the full amount remaining due on the account, less any payments.
And Ms. Perkins, is that your agreement?
Yes.
Do you have any questions?
7249 for the plaintiff.
And I'm Nicholas Weatherhead.
Thank you. Counsel, what do you have today?
Mr. Weatherhead and I think, had a meaningful conversation in the breakout room. We don't have resolution today, but Mr. Weatherhead's going to email me a settlement proposal to take to my client before the end of the week. We'd ask for a pretrial, an additional pretrial. I know Mr. Weatherhead has a work trip coming up in August, but if we can get a date, maybe after that, we'll either have resolution or ask for a hearing.
Heather, we got a date?
I have August 20th.
How's that, Mr. Weatherhead?
I'm out of the country August 12th through the 21st.
Okay.
You want to do something before August 12th?
We can do it before. I'm going to get my.
You got anything?
Yeah. Is this going to be in person, Judge, or by Zoom?
I'm assuming, looks like it's probably likely to settle. Let's do it by Zoom, fellas.
Thank you.
Works with me.
July 30th?
1 moment. What time would that be?
What time, Heather?
I have 8:30.
And
If
I
that's-
apologize. I know that I just had thumb to that. I've got an in-person in Pontiac in the morning and an in-person in Westland in the afternoon. So I appreciate this can be by Zoom, but those are gonna be killers.
August 5th, excuse me, August 5th.
Sure. What time again?
Either I have one in the afternoon or we can do August 6th in the morning.
I would prefer August 6th in the morning if it's the same as Mr. Weatherhead.
I can do that.
All right, 9 a.m.
Okay.
Good
Same
luck, gentlemen.
meeting and everything. Same meeting number and everything.
Correct.
Okay.
Correct.
All right. Thank you, everyone.
All right, we'll see you in August.
Take care.
Goodbye.
Today's date, was it supposed to be live or Zoom?
It was supposed to be, so.
Heather, what did you think was scheduled live today at 9:30?
I'm sorry, Judge.
The calendar says we had something 9:30 live. But
Yes.
the docket doesn't reflect that.
Let me ask Sandy real quick.
You happen to know what happened? Did her show up?
It was the Sire versus Lehman at 9:45, but Fanto was unable to do it, so I think we granted him an adjournment.
Thanks. Hey, do you know if my guy showed up, Hurst showed up on the creditors exam for 9 o'clock? Hurst and Galindez. Galindez was here. Thanks. Thanks. Okay. Hurst never showed. Thanks. So on that, we'll just make a note that he emailed us yesterday, wanted to reschedule. We didn't respond, and Galindez showed up today, but he didn't. Thank you.
Judge, do you want Galinda to come up regarding that case?
I think the guys already let him go, because I told the guys that if Hurst didn't show up by 9:30, Galindez could go.
Okay, so you've already spoke to, okay.
Yeah. You have to do something else, yeah. We know anything about Lakeview versus Smith at 9?
I'm sorry, they were
Coots is the
no-shows.
attorney?
Both of them no-showed from what I understand. Maybe they sent something in.
Probably.
Hi, Mr. Mueller.
It's crazy. We got 4 files scheduled at 9:30. 2 of them we haven't heard a thing from.
Yeah.
The last 2.
Judge, are you talking about our
Consumers.
9:30 right now?
Consumers Credit and Oliphant Financial. We haven't heard anything, have we?
Oliphant is in a breakout room.
Oh, okay.
I don't see a
Consumers Credit versus Webster.
I don't have that
Third
one on
one
my,
at the, yeah, third one at the 9:30 time slot.
oh, it must have been added. Let's see. No, that one's not even on the docket anymore, so you must have an old docket maybe?
Yeah, okay. So scratching Oliphant.
No, Oliphant is here, the consumer credit one
Oh,
to scratch.
scratching consumers.
Yes, please.
So I didn't catch, I was talking to Malachi. I assume Ms. Pullman was bitching about the delay in proceedings.
She called you an asshole.
Called me an asshole because I gave her the
Yeah.
adjournment she asked for.
Well, and because I don't think she asked for it. When I told her that we were recording and we heard everything, that the case got adjourned, and she started yelling because it sounds like she didn't want it to. She's like, I've been asking for this for months. And so that's why he kept on saying.
Send in the stipulation to adjourn.
I think it was Callahan.
She actually contacted the civil department from what Jack told me and
Yeah,
asked us.
she's been sending emails and asking for an adjournment.
And then
Yeah, so maybe she's the one that, I don't know.
contacted the defendant's attorney.
Well, here's what we're gonna do.
Uh-huh.
You remind me, next time we schedule,
Mhm.
everything on this file from here on out is live.
Well, that's what originally I think it was going to be until I think because he's been sick, but I think it was
Yeah,
live.
It's all going to be live from here on out. I'm not dealing with this on Zoom.
Yeah, because remember it was live last time because that one attorney was the one that informed you.
That's right. That's
And
right.
then
Yeah, that's right.
this one I think was supposed to be live, but nope, it says Zoom. Sorry.
Yeah, as recently as yesterday, she had sent an email in and referencing a hospital stay that was 4 days ago. So I told Sandy, I said, no, not without a stipulation. So this morning when I'm in on base, there's a stipulation to adjourn. I signed it.
Wow.
So obviously she doesn't know what's going on either. Gomez Adams says, he who represents himself has a fool for a client. I'm not sure what that means about the guy that represents his wife.
Yeah. This case has been crazy ever since I've started hearing about it.
Heather, we need to get Mr. Harper out of the breakout if we can.
Yeah, I will work on it. Let's see.
Good morning, Judge. Good to see you, sir.
Always good to see you, Mr. Mueller. We're trying to get Mr. Harper out.
Good guy. He was easy to talk to.
Let me jump in there and tell him to get out.
That's always a plus.
Right.
How's business?
We're keeping busy. I mean, it's moving, and we're sending a few more pieces of paper through your court to Mike Jones these days. He's good. He's good at what he does.
Good.
But it's nice to hear that Vic's back on the mend, and his wife as well. They both were fairly ill for a while. No question about it.
Yeah, I didn't hear about his wife's problems. That is good to hear.
Yeah, no. Boy, that Vic doesn't want to stop though. That guy, he's a rolling train.
And you know, I'm gonna guess he's probably 82-ish.
Yes, absolutely. Right around there. Yes. Yeah. He's got a lot of vinegar in him still, but that body's not keeping up with what his mind's telling him. I hope I have that much energy in me.
Well, I'll tell you what, my mother's going to be 95 in November. She still lives alone, still drives, plays cards 3 days a week.
Oh, that's great. That's fantastic.
She earned it, though. She always took real good care of herself. Mr. Harper, can you hear me okay?
Yes, Your Honor. How are you?
Good morning, sir.
Good morning.
Mr. Mueller, your appearance, please.
Good morning, Your Honor. Richard Mueller, P58626, on behalf of Plaintiff Trailer Express, Inc.
Did you gentlemen have any luck in the breakout room, Mr. Mueller?
Your Honor, Mr. Harper and I had a chance to have a very nice conversation. Unfortunately, I explained to him that he was able to give me much more details, let me put it that way, in the breakout room than what's on his motion. So pursuant to his motion, I wasn't able to get authority for my client to set aside the judgment. I explained to him that we would have to move forward and let Your Honor make the decision, and then we would go from there.
Okay, let's go there. All right, Mr. Harper, when somebody schedules a motion to set aside a default judgment, there are two questions I need answers to. Number one, was there a good reason why the default was entered? In other words, I think in this case, Mr. Mueller, help me, I think the default was entered for failure to answer?
That's correct, Your Honor.
Okay, so the first question, Mr. Harper, is why did you not answer? Did you have a good reason for that? The second question I look at is, what's your defense to the underlying claim? Do you have a valid defense to the underlying claim? Both of those questions I have to answer with a yes before I set aside the default judgment. You can take those questions in whatever order you would like and go ahead and answer them now. So why didn't you answer, and what's your defense? In whatever order you like.
The house that they've sent them to, I'm not residing in. Me and my wife is in a separation after 32 years of marriage. I did not get the information until after the judgment, the default was already set in. As soon as I got that, I tried to take action, and I asked the court to set it aside. And
let me stop you right there, Mr. Harper, just for a minute. Mr. Mueller, how was service made?
I was just pulling that out of my file. According to what Mr. Harper is saying, I would assume that's correct because it was by alternate service, and I see the certified mailing, assuming this is Mr. Harper's separated or ex-wife, was signed by a Lynn Harper. And then posting was done at 22359.
Thank you. All right, Mr. Harper, and what's the underlying claim to or underlying defense to the claim, sir?
I disagree with the damages that's being claimed. It was internally, there was a blowout on the trailer, and it was internally decided by them at one time, and still is, in my opinion, that I wasn't responsible for the damage that the blowout of the tire caused. And then they're claiming that there's some support beams inside the trailer that was damaged, but on the intake, when you return the trailer, you get an intake inspection. It was a 100% pass. And if you look at their own pictures that they took on the in gate, them support beams are clearly in good condition. There is no damage on them. And they even number them. You can count them as you look at the pictures that they took on the in gate, and there's nothing wrong with them.
Okay. So if I understand this, go ahead.
And when I went to look, because at first they tried to charge me for the damage on the tire, and I asked them if I could meet them and look at it, and they said, yeah, come on down. I went and looked at it, and I explained it to them. They were kind of hostile in the garage a little bit, but I explained to them that that was already decided. It wasn't my responsibility. While I'm here, is there any other damage that you guys are claiming that I can look at? And they said no. So then I left. So I have an in-gate complete 100% pass. And when I was there, they only showed me the damage that the tire done and said there was no other damage for me to look at. And then I left. And then I got this through the invoice, and I called them and I asked them if I could come and see that damage. They said, yeah. Well, when I got there, the trailer wasn't on their premises. I don't know if it was already leased out but the trailer wasn't there for me to look at any of this damage. And then if you read what they're saying, and if you look at their own in-gate, picture photos and stuff, I just don't see I don't see it.
All right. So if I understand correctly, the underlying claim is for damage to the trailer and some missed rental payments. Is that correct?
Yeah, the missed rental payment was because I had the trailers. I had like 3 of them out at one time. I never missed a payment. I was never late on a payment. The only reason why the last payment was missed is because when I left there, the garage people told me that don't worry about it because we're just going to deduct it because ACH payment was on all my payments, and they told me that we'll just take it right out of your bank. So I went and took the money out of the bank so that they couldn't take it out. And I agree that I do owe them the last payment. But I only took it out of the bank and didn't make that payment because they said that it was all affiliated with the damage that they were claiming that I don't agree with.
Okay. All right. Anything else at this point, Mr. Harper?
No, Your Honor.
Mr. Mueller, any response from the plaintiff?
Thank you, Judge. Yeah, the summons and complaint was served by alternate means as explained earlier. Mr. Harper's explanation is almost exactly what he told me in the breakout room. He does admit to I think the first 2 invoices attached to the summons and complaint, which was the GPS rentals him and I were discussing. The biggest dispute is the last invoice for the damages that my client alleges took place. Again, because I just received so much more description and detail from Mr. Harper, I've not been able to address those issues with my client. However, according to the terms and conditions, there are certain damages to trailers that are not covered by the additional, maybe possible insurance that I think that was in the terms and conditions. And my client says these damages that took place are outside of the terms and conditions, and that's why he's responsible. As to that, Judge, I'm just moving forward on a contract issue in which there's some balance due and owing, and I can't respond in any details to his allegations as to no damage to the trailer.
Okay, thank you.
Absolutely.
Mr. Mueller, when was the service made at the home? If you have a date.
Absolutely. The summons was posted on March 29th, 2024.
All right. And Mr. Harper, when did you move out of the residence?
It was late December.
December of 23, correct?
Correct.
Okay. And did you do a change of address with the post office?
No, sir. No, Your Honor. I still own the house.
Yeah, and unfortunately,
Okay.
that's what I was going to bring up. Of course, in order to do our motion for alternate service, we do a postal trace, which confirmed that address is still being a good address.
Right, right. Okay, Mr. Harper, here's where we're at. I'm sympathetic with you, but unfortunately, the plaintiff did everything they could do to effectuate good service on you. You were out of the house for almost 4 months without changing your address. So I'm not going to set aside the default. What I will do is I will set a hearing on damages. So you're liable for a debt to the plaintiff. I'll determine how much that debt is after we have a hearing. So that'll give Mr. Mueller a chance to talk to his client. Sounds like you fellas are working well together, so I would encourage you to exchange some information. Mr. Mueller, why don't we give you a date like 30 days down the road?
Yeah, that should be enough time for my client to respond. And I will say, Mr. Harper's already provided me with his phone number and email, so we can exchange some documents as well.
All right. So Heather, and fellas, I'm going to set this hearing. I want that live. If I'm going to look at pictures and documents and everything, I want that live. So I'll give you a date. If you resolve it beforehand, that's great. Just let us know, and then you won't have to drive to the court. Heather, you got a date approximately 30 days down the road or longer?
30 days or longer. Let's see. We're into August. We have our August 20. Well, August 20th is our regular civil docket. We can do it at 1 o'clock that day.
That'll work.
I mean, unless you want to do it in the morning.
That's a good time for me, Judge.
Scheduled
August 20th at 1 p.m.
Heather, what's a docket look like? We could probably do it late in the morning too.
Well, that's what I was just thinking, but I just don't know about lunch because it's a Tuesday. It'll run into
August
that.
20.
Yeah.
How about 11 o'clock that morning, gentlemen? August 20, 11 a.m. Mr. Harper?
Yes.
Okay. And once again, if you fellas work out, you come to a resolution beforehand, just let us know.
Absolutely. Thank you, Judge.
Mr. Harper, do you have any questions, sir?
No, Your Honor.
All right. I wish you luck.
Thank you, Mr. Harper.
Good to see you.
Yes, thanks, Judge. Good to see you.
Have
Mr. Harper, I'll follow up with you, sir.
Thank you, sir. You have a good day.
You too. Thank you.
Tranisha Willis, what are you here for?
Yes, I'm here. I'm sorry, I'm late. I didn't know I was scheduled for 9 a.m. They told me to hop on. I just didn't want to miss my time.
Do you have a case number?
I don't think she's in the right docket.
I don't think so either. Do you have a case number? I looked her up in our whole system and I'm not finding her name.
We got her?
Yes, I just called into the clerk. She said that
Do you
I
have
was
a case
scheduled
number?
I do not have it with me at the time.
Oh, hold on. She might be on the Unifund. Is
Yes,
it Tranisha Jones Diggs?
Diggs Jones, yes.
Oh, okay. Yeah, Miss Nelson,
Yeah, there was a default. The plaintiff is asking for a default judgment because you didn't show up by 9:30, half hour after your scheduled date. So that will be submitted to the court. You can file a motion to set aside that default judgment if you'd like.
Okay, thank you.
Good luck.
and Judge, do you see that Mike John is here for Menards, for the Pullman Menards
Oh, I did
case?
not catch that. Thank you. Counsel for Menards.
Yes, Your Honor.
Counsel, this has been a confusing case. We've been receiving communications from the plaintiff repeatedly about Mr. Pullman's health problems. I've repeatedly told her I need a stipulation to adjourn. As recently as yesterday, she sent something in about him being in the hospital 4 days ago. Once again, we said we needed a stipulation. So this morning I got a stipulation in my e-file. I signed it. Mr. and Mrs. Pullman showed up on Zoom probably 15 or 20 minutes ago. She was pissed. He was confused, and I told him that I'd signed the stipulation. And Mr. Pullman said, well, that would be good with him because he's still not thinking clearly with his health issues. So I don't know where the stip came from. I just had it in my file and I signed it.
Your Honor, my office submitted that attached to the stip where it was an email chain between Ms. Pullman and I, and she, in her email, said the court required that. And she said, what am I supposed to do? I can't do that. So I said I would prepare that, and that was submitted on Monday. And obviously
Well, bless your heart.
It reached you. And
bless your heart. It made it to us. I signed it this morning.
Okay.
I don't know why she was so upset unless she just doesn't understand the process. But so just so you know, I'm going to reschedule, but we're not doing any more Zoom with this one.
All right, Your Honor.
All right. Thank you, counsel. And once again, thank you for your graciousness.
Thank you. I appreciate it.
We need more of that in our profession. Have a good day, counsel.
Zachary, we're just waiting for Bert to show.
Sounds good.
Oh, wait a minute.
Jordan Nelson's the other side.
Yeah, okay. I'm sorry. Yep. I just got that confused. We're waiting for Jordan to show.
Oliphant.
Alexa, we're waiting for Bert. I'm sorry, Judge.
Oliphant, whatever happened to that one?
They're still in the breakout room.
Okay.
It's kind of, they shouldn't without contacting you, otherwise they just pick my schedule. So usually it's just, adjourned to a date to be determined or something. And if they didn't contact us about it, which I'm assuming they didn't, because he didn't mention anything, and I didn't even notice when I signed it. Just talk to her. We'll just do it.
Heather, when's our next regular civil docket?
It is General Civil, August 20th.
Man, that seems like a long time, but it really isn't, is it?
It is, but we're only on the 16th. That's
I'm inclined to try to pick a date sooner than that for Pullman and Menard.
Okay.
Hello. Hello.
Hi, Carrie. Hold on one second. Let me see where the attorney is. Do you have a camera, Carrie?
I do.
Okay. If you can turn it on.
Oh, I'm sorry. I didn't know it was off. Because it was just on. I apologize.
Oh, that's fine. There you are. We see you.
Oh, okay. There you go.
This is the Oliphant case, Judge.
All right, counsel, are you ready on Oliphant?
I'm ready, Your Honor.
Your appearance.
Attorney Elizabeth Ellison, PA 2098 for the plaintiff, Your Honor.
Thank you. And Ms. Pearson, you can hear me okay?
I can, sir.
Thank you. Counsel, what do we have?
Your Honor, we just need a standard scheduling order. I was thinking 60 to 90 days for discovery and then a motion date.
Written discovery?
Yes, please.
And you think it's, excuse me, summary disposition?
Yes, Your Honor.
All right, I'll have you contact the court and schedule that.
Thank you, Your Honor.
All right, Ms. Pearson, I know we tend to speak our own language, so let me tell you where we're at. A pre-trial is an opportunity for the judge to get some information about the file, hopefully put it on a calendar and move it towards a resolution. So counsel is asking me for a discovery period. Discovery is an exchange of information. It's meant to be a two-way street. So counsel will probably, I'm making assumptions now, but probably will send you a list of questions she wants you to answer. You can do the same thing. There might be documents that you think that Oliphant has in their possession that you need to prepare your defense. You can ask counsel for those documents. Once again, it's a two-way street, this exchange of information. Based on what she expects to get in that discovery process, she thinks she might file a motion for summary disposition. Basically, what that is a legal argument that based on the law that applies to the facts in this case, the facts that are not in dispute, they're entitled to judgment. She'll file a written document to that effect. You'll get a copy of it. I'll encourage you to file a written response. We'll also have a hearing date where you can respond orally. If I follow their argument, in other words, I agree with their argument, there'll be a judgment against you entered at that point. There'll be no trial. If I deny their judgment, if I disagree with their argument, then we'll talk about a scheduled date for a trial. You understand all that process I just explained?
Yes, sir, I do.
Do you have any questions at all, Ms. Pearson?
No, I don't.
Okay, so you'll get a notice from the court for that date that's going to be down the road for a summary disposition motion. In the meantime, counsel will probably send you some discovery requests. Anything else, counsel?
And I have one.
Nothing else from me, Your Honor, but I'll wait for her.
Go ahead, ma'am.
I have one thing. Could you make sure that they send everything, like, because when I received my first paperwork for my response, they didn't send me everything. I literally had to write on the back of the paperwork. The court reporter told me the clerk told me just to write on the back of the paperwork because they wanted response to questions, but the form that you're supposed to write on, they had not sent.
Okay, I have no idea what you're talking about.
Okay, when she originally filed for my response for this hearing.
Okay, I don't know what response, ma'am, I'm sorry. This is a pre-trial. Okay. I don't know what you're talking about with a response. What was sent to you that was incomplete?
Yeah, it was questions sent to me from the courthouse, from her that were incomplete. I didn't get all the paperwork. That's what I'm asking.
Ma'am, that's what I'm trying to establish. What document did you get that you don't think was complete?
The original form that I had to fill out my response.
You mean an answer to the complaint?
Yes.
Okay. I don't know who sent you that form. I don't know who sent you that form. Nobody has an obligation to provide you an answer form. The plaintiff doesn't, the court doesn't. If you're going to file an answer, that's on you to prepare the answer.
No. Okay. No problem. I wrote on the back of the form. It was fine.
Okay.
But
all right. Anything else?
No, that's it.
All right. Good luck to you, ma'am.
Thank you, Your Honor.
Thank you, counsel.
Have a good day. Are we finished?
We are, ma'am.
All right. Thank you.
I don't know who would have been sending forms other than someone's complaint. Right. Well, the good news is she obviously doesn't get sued a lot. She doesn't understand how it works. That's a good thing. Yeah, she said 60 to 90. I said 60 days discovery. She's supposed to file it.
In this courtroom moment, the judge is handling multiple civil cases during a busy virtual court session. Attorneys and defendants join through Zoom while the clerk organizes the cases and places people into breakout rooms so they can discuss settlements. One case involves a financial dispute where the parties agree to a consent judgment, meaning the defendant will repay the debt in monthly installments. The judge confirms that the defendant understands the payment terms and has no questions before the order is finalized. In another case, the court schedules additional time for discovery so both sides can exchange information before moving forward. The judge explains the legal process clearly to the defendant, including how motions, hearings, and possible trial dates will work if the dispute is not resolved. These routine but important court procedures show how judges manage cases, guide defendants through the legal system, and keep the courtroom moving efficiently. If you enjoy real courtroom moments and legal breakdowns like this, don't forget to like the video and subscribe for more courtroom content.